Good evening, everyone, and thank you for participating in Cancer Council Victoria's webinar on alternative therapies in cancer care, regulation and risk. My name is Sonia Brockington. I'm the Knowledge and Training Manager for the McCabe Centre for Law and Cancer, and I'm very happy to be your facilitator this evening. Before we begin, I would like to acknowledge the traditional owners of the lands we are meeting on today. I would also like to pay our respects to their elders past and present and all Aboriginal people participating. Today's webinar will be 1 hour and 15 minutes. This will be followed by 30 minutes of question time in which participants can stay online to participate in a Q&A with our panellists. You will notice there is a question and answer function within this webinar platform. Please note we have disabled this function at the moment, but this will be available to you at the top right-hand corner at the conclusion of this webinar. We hope that many of your questions will be answered during the webinar, but the Q&A period will provide the opportunity for any unanswered questions to be addressed, so we hope you will be able to join us. In relation to tonight's topic, we understand that what we are discussing can raise sensitive issues that may be upsetting for some people. If you do find that the discussion is causing any distress, you may like to call Cancer Council's 13 11 20 number, which is staffed from 9 till 5 Monday to Friday by practicing cancer nurses who are on hand to provide information and support whether you have cancer or are a family member, friend, colleague or health professional. This service is free and all calls are confidential. The key question that will be answered in tonight's webinar is this. As a health professional, I'm concerned about particular alternative therapies being offered to my patients. What can I do? Therefore, our focus tonight is on how alternative therapy practitioners are regulated and how concerns about their practices may be addressed. We are not talking about how medicines, whether conventional, complementary or alternative, are regulated, but how practitioners are regulated. The particular focus is on the small group of providers who are financially and emotionally exploiting patients or who are otherwise making false or misleading claims about their therapies. It is important to emphasise at the outset that every competent patient has the right to choose whatever treatment or course of treatment is offered to them. Patients have the right to choose alternative therapies in preference to or alongside conventional or complementary therapies. Patients' choices must be respected by their treating teams. However, it can be distressing for healthcare professionals to see their patients reject cancer treatments with curative, palliative or life-lengthening possibilities in favour of unproven or even dangerous alternatives. It may be particularly distressing if you have additional concerns about patients being financially exploited by unethical alternative therapy providers making promises about cancer cures. Please note that the content in this webinar is general information only. The information is not intended to be legal advice and should not be relied on as such. Also, some of the legal information in this webinar is Victoria specific. Our presenters will make it clear when they're speaking about Victorian-specific laws. And please contact your local state or territory cancer council for information about the laws and processes in your own region on 13 11 20. Tonight we'll discuss some of the concerns about alternative therapies offered in cancer care may be addressed within the parameters of respectful clinician-patient relationships. Medical oncologist Dr. Tony Dowling will use a case study to illustrate some of the concerns and challenges raised by alternative therapies in cancer care and provide some practical strategies for discussing alternative therapies with patients, including some useful resources you can access. Dr. Deborah Lawson will then provide an overview of how practitioners are regulated in Australia, with a focus on avenues for making complaints about unethical or unsafe alternative therapy providers. Heidi Snell from the Australian Competition and Consumer Commission will present on the role of the ACCC in responding to complaints about representations about healthcare and misleading or deceptive conduct in relation to the provision of healthcare. Finally, Victoria's Health Service Commissioner, Dr. Grant Davies, will talk about the functions and powers of his office with an emphasis on unsafe or unethical alternative therapy providers. Dr. Davies will also discuss key recent policy developments in this area. And at this point, I will hand over to medical oncologist Dr. Tony Dowling.
Okay, so welcome everybody. So yeah, I'm Tony Dowling. I'm a medical oncologist working at St Vincent's Hospital in Melbourne. I think it's useful to sort of set the scene of what we're going to be talking about tonight, and you've got this slide in front of you. And I think this is useful to look at what we mean by the terms that we're going to be talking about tonight. So there are three broad categories that you can see there: conventional, complementary, and alternatives. The focus of this webinar is on regulation and risks related to provision of alternative therapies in cancer care specifically. But just looking at conventional, that's what we're all quite familiar with: the medical, the proven, orthodox, or even Western medicine. It can be used alone or in combination, and generally it's cancer specific. Examples of things that I would use, such as chemotherapy, hormonal therapy, radiation, and obviously surgery is an important pillar in the conventional treatment of cancers. Complementary is another category, and there's some examples there, such as acupuncture, aromatherapy, art therapy. Some of these have been well proven in clinical trials to help with the symptoms of cancer. Acupuncture with nausea and vomiting following chemotherapy would be a good example of that. The focus here is really on the whole person, and by and large, complementary tend to involve things that are not ingested or taken into the body, but are used in conjunction with, hence the name complementary. Alternative is the other category, and I guess this is really what the emphasis is on tonight. Many of these things are unproven, and they're certainly unconventional treatments. They, by and large, haven't been subjected to the same amount of scientific rigour, usually in the form of clinical trials, that certainly conventional treatments have been used for. Examples you can see there include such things as microwave therapy, ozone therapy, magnet therapy, with various immune therapies. Laetrile, I think, is an important one to emphasise because there is quite a bit of evidence of harm that can come from that, and such things as shark cartilage. I think the emphasis there is most of them have not been subjected to scientific tests and rigour in the setting of well-done clinical trials. So I think one of the concerns I guess I have as a medical oncologist is that it is very important to talk about these things. The evidence tells us up to 3/4 of our patients are using alternative therapies, and so it's certainly a very important component of their care. But my concern is a lot of the time is that people who promote these activities can often promote false hope. And it's a very difficult balance, certainly as a cancer clinician, trying to get somebody to be realistic in the fact that they may have an incurable cancer, but not also get rid of hope. But equally, false hope is also dangerous. And that's one of the concerns I have as a cancer clinician, that a lot of these alternative health providers do offer false hope. And if I can quote an example, every year I see 1 or 2 cases of very neglected breast cancers that have been being managed by alternative therapists, and they come in usually with ulcerated, smelling, quite disgusting breast lesions that have been neglected. And if you ask the women why they sort of kept going with this and what did they think was happening in the face of a lump that was obviously getting bigger and even starting to erode through the skin, they're told such thing as, well, the treatment, it was running away from the needle. So even though it was getting bigger, there was still, an obvious, supposed benefit. And it can be quite difficult to convince people that, such things just fly in the face of reality. If something is getting bigger, then most people would then interpret that as the therapy is not working. So I think some practitioners can be very good at manipulating this and giving people false hope. So I think it is very important that we talk about these things, especially, as I said, a good 3/4 of our patients are on them. So my concern is that patients often delay presenting to conventional treatment because they're using an alternative therapy, and I think that can be very harmful. The example of breast cancer I gave is a very good example. really the only chance you have of curing your breast cancer is to have it surgically removed. So anything really that delays proceeding with surgery is really, I think, inappropriate care. In addition, the harms or benefits of using either an alternative or conventional treatment can be misattributed, and we also don't know about potential complications, interference with chemotherapy. Many people think that herbs are natural and safe, but we know that's not the case. There are many known examples, and I think if we studied this further, we'd have a lot more examples of how lots of medicines, so-called herbs, can interfere with chemotherapy, either making them more effective or interfering with their metabolism and therefore less effective. So the possibility of interaction effects, I think, is really real. So St. John's wort, garlic, even grapefruit juice are examples of things we know that can interfere with chemotherapy treatment. So I think unless you discuss openly with your patients what they're on and know what they're taking, it can be very difficult to know whether or not there are any potential interactions and things that could potentially harm our patients. So I think knowing the motivation for patients, why they're taking alternative therapies, can provide valuable information about their beliefs and expectations. We know that by and large these people tend to be women, they tend to be well educated and well informed, and they often have very strong beliefs. And that's fine, we can work together with that, but I think it's all about working as a team and knowing what the left hand and the right hand are doing so we can give optimal care. And I think that's important when we try and build a trusting relationship so that we can enhance the delivery of patients using, again, a holistic care approach. So, it is important that we talk to our patients. And I think that as the first question they had just asked, this should be a standard question in any medical visit. It's not one that I always do, I have to confess, but I think it's an important one that we do. And I think it's important that we explain the evidence. Most of the medicines I give have been subjected to vigorous clinical trials. That doesn't mean that we have all the answers, but at least we have some answers. But often the trials themselves do open up more questions, but at least it gives you a basis to start a discussion. I think it's important to be non-judgmental and acknowledge that we need to work together in this arena. And obviously patients have their own wishes and they are responsible for their own health, and we need to support their autonomy in making a decision. But I think unless we do that together and have open discussions, it can be very hard to have an open and frank discussion. But it should be shared as well. And I think at the end of the day, even if you look at the financial literature, if somebody comes to sell you something and it's too good to be true, then it probably is. And I think that's very important when it comes to medical care, that we have to keep things in perspective. And quality of life should be the overriding arch to what we do with our patients. If we can't cure somebody, then we have to make sure that as best we can, we try and maintain or improve their quality of life. So there are a number of very useful resources out there for you and your patients. The Cancer Council has a number of these, and they are certainly available for free and by bulk order. And some of them are listed here. The Understanding Complementary Therapies book, I think, is excellent. It's very well written and it's very informative. There's also a Victorian fact sheet on complementary and alternative medicine, how to communicate with patients. And there's also one about making informed decisions. And then through other peak bodies around Australia, such as the Cancer Council Australia, COSA, which is the Clinical Oncology Society of Australia, these peak groups also have position statements on complementary and alternative therapies. And these websites and resources will be available at the end of the presentation.
Great, thanks for that, Tony. So this is Deborah. I'm a legal policy advisor from Cancer Council Victoria and the McCabe Centre for Law and Cancer. And before I begin, I just wanted to make it clear that we respect patients' rights to choose their own treatment from those on offer or to reject treatment altogether, regardless of the potential risks. But the focus of this part of the webinar is on actions that health professionals might consider taking if you're concerned that your patients are being financially exploited by providers of alternative therapies, or that the risks to patient health or the health of others is so significant that you feel you need to act. Many of the complaints mechanisms we're discussing tonight are geared towards patients who want to complain, but it is possible for healthcare professionals to report their concerns in certain circumstances. And it's strongly preferable that you do have your patient's consent to report a concern about an alternative therapy provider, Obviously, having consent will mean that you're able to support the patient to make their own complaint, or that you'll be able to provide more information to the body that you're complaining to on their behalf. However, in many cases, as Tony's just outlined for us, your patient may believe in the therapy that they're having and not see grounds for complaint, or they may lack the will or the energy to be interested in participating in a complaint. So if you're still concerned about the claims or actions of an alternative therapy provider because of the risks to your patients or others, there are a few actions you could consider, which will depend to some extent on the information that's publicly available about the services. I'm going to provide some brief context about how health practitioners are regulated before discussing potential complaints mechanisms if you have concerns that can't be addressed by talking to your patient about their alternative therapies. So Australia has a two-tiered legal framework for the regulation of healthcare practitioners, with the division between those who are registered and those who aren't. The most rigorous form of regulation applies to health professionals who are registered under the National Registration and Accreditation Scheme. The Australian Health Practitioner Regulation Agency, or AHPRA, administers the national scheme and provides administrative support to the national boards, which represent each of the registered health professions and have particular responsibility for registration and oversight of practitioners and students. There are currently 14 registered professions, which you can see on the slide there. Registered health practitioners, including GPs and other medical practitioners, may offer alternative therapies instead of or in addition to conventional and/or complementary treatments. One of the most significant features of the national scheme is the authority given to the relevant body to discipline registered practitioners. Lesser breaches of professional standards can be dealt with by the national boards. Cases involving professional misconduct, which is the most serious breach, must be referred to the relevant state or territory tribunal, which is VCAT in Victoria, which has the power to suspend or to cancel registration or place conditions on practice. Where a practitioner is deregistered, VCAT can also disqualify that person from applying for registration for a specified period, prohibit the practitioner from using a protected title such as medical practitioner, and prohibit the practitioner from providing a specified health service. For example, they could prevent a psychologist from practicing as a psychotherapist or as a counsellor. Anyone, including a health professional, can make a complaint called a notification to AHPRA about a registered health practitioner. A notification may be made on any of the grounds set out under Section 144 of the Health Practitioner Regulation National Law Act. Relevant grounds for our purposes tonight include that the practitioner's professional conduct is or may be of a lesser standard than that which might reasonably be expected by the public or professional peers, that the practitioner's knowledge, skill, judgment or care is or may be below the standard reasonably expected, or that the practitioner has or may have contravened the national law. To make a notification, they can be lodged over the phone, via completion of a prescribed hard copy form, or in person. A patient's consent isn't required to make a complaint to AHPRA, but it is preferable, and there's an appendix to the form on which patients can sign their consent. If the complaint meets the grounds for a notification, it's assessed by a national board. A copy of the notification is provided to the practitioner who is being complained about, unless there is a risk to safety if this is done. The national law provides protection for people who report from civil, criminal and administrative liability for people who make a notification in good faith. I'm sure that most of you are aware that health professionals also have mandatory reporting responsibilities. So registered health practitioners and employers must make a notification to AHPRA or the National Board if they have a reasonable belief that a registered health practitioner is placing the public at risk of harm or engaging in other notifiable conduct. So a registered health practitioner who provides alternative therapies in a way that places the public at risk because of a significant departure from accepted professional standards could be the subject of a mandatory notification. Each national board has guidelines on mandatory notifications for its profession, and further information is available on each of the national board websites. So on this slide is an example of a professional misconduct action against a GP who placed patients at risk through his use of alternative therapies. Dr. Nguyen Phuc, a GP, had a history of providing complementary and alternative therapies to his patients. One of a number of complaints made against him came from Dr. Cleland, a nephrologist. Dr. Cleland wrote to the New South Wales Medical Board to voice his concerns after one of his patients was treated by Nguyen Phuc with intravenous vitamin C over 3 days. Dr. Cleland was concerned that the treatment had contributed to the patient's rapid decline in renal function. As a result of the vitamin C treatment, the patient was placed on permanent dialysis therapy earlier than would otherwise have been necessary. Nguyen Phuc conceded that he had not been aware that high doses of vitamin C could cause the formation of oxalate crystals, and he hadn't consulted the patient's treating specialist, Dr. Cleland, before commencing the treatment. The medical tribunal found Dr. Nguyen Phuc guilty of professional misconduct and reprimanded him, in addition to placing restrictions and conditions on his ability to prescribe certain drugs. It also ordered that he be supervised and submit to random audits of his medical records, that he cease working as a sole practitioner, thereafter practicing only in a group practice with at least one other practitioner always on site. And before I move on to discuss the regulatory framework for unregistered health practitioners, I thought it might be useful to mention that you can easily check whether a health practitioner is registered by searching AHPRA's online national registers of practitioners. By typing in the practitioner's surname, you can see whether or not they're registered, and if they are, for which profession, and the registration type. If they're not on the registers, then they're not a registered health practitioner. Most alternative therapy practitioners do not belong to one of the registered health professions and are therefore not subject to the same regulatory oversight. Regulation of unregistered alternative therapy providers does differ between states, and no comprehensive regulatory mechanism currently exists for unregistered practitioners in Victoria. However, providers who act unethically or in an unsafe manner may be held accountable through a number of ways, including through self-regulatory bodies, the national law in limited circumstances, consumer protection law, and the Office of the Health Services Commissioner. In terms of self-regulation, the alternative therapy industry in Australia is largely self-regulated. Many unregistered practitioners belong to voluntary professional associations, which vary in the regulatory approach. Many operate a complaints process through which individuals, including health professionals, could make a complaint. However, even if a complaint is made out, the disciplinary powers of these bodies are ultimately limited to suspension or exclusion of the person from the relevant body. Unlike the national boards in respect of registered practitioners, professional bodies for unregistered practitioners can't prohibit a person from providing a particular health service. And if an alternative therapy provider is not a member of an association, or they choose to resign from the association to avoid being disciplined, then there's no avenue to pursue the complaint through this mechanism. While most alternative therapy providers aren't registered under the national law, it can still impact on them in certain circumstances, particularly in relation to holding out offences and restrictions on the use of professional titles. So under the national law, only people who've met the requirements of the national law can use a protected title such as medical practitioner. Where an unregistered health practitioner unlawfully uses certain professional titles or misleads people into believing that they're qualified and registered when they're not, they may be guilty of a holding out offence. As I mentioned earlier, you can check whether they're registered or not by searching the national registers of healthcare practitioners. If you're aware that an unregistered health practitioner is holding him or herself out to be a registered practitioner, whether generally or in respect of a specific profession, you can make a complaint by calling AHPRA or completing an online inquiry form. And I'll hand over to Heidi now to talk about the role of the ACCC and complaints against unethical or unsafe providers. Before I do, I just wanted to mention that from our perspective, consumer protection law has proved to be a particularly important tool in respect of unregistered health practitioners who make false or misleading claims about the treatments they offer to cancer patients. And while consumer protection law applies equally to registered and unregistered practitioners, in the absence of the type of disciplinary powers available to the registered professions, such laws can serve a more significant regulatory function in relation to unregistered practitioners. Thanks, Heidi.
Thanks very much, Deborah. So briefly tonight, I'll be covering the ACCC's role, the key legislative provisions that are relevant to the medical and health sector, our enforcement and compliance policy, which informs what matters we pursue, and some examples of actions that we've taken that will give you a sense of what sorts of things we pursue. And then finally, I'll talk a little bit about how to make a complaint and the process from there if you do wish to make a complaint. So the role of the ACCC is to enforce the Competition and Consumer Act, of which the Australian Consumer Law is a Schedule 2. The Australian Consumer Law is a national consumer protection law, and the ACCC jointly regulates the Australian Consumer Law in conjunction with state consumer affairs and fair trading agencies. And in certain circumstances, we may recommend that you make a complaint to them rather than us. And I'll talk a little bit more about that later. So the ACCC typically focuses on matters that have impacts on consumers nationally or otherwise fall within our priorities, one of which this year includes the medical and health sector. So the most relevant provisions of the ACL to healthcare claims are those relating to misleading and deceptive conduct, which is sections 18 and 29 of the ACL. And some key examples there. Under section 29, there's prohibitions on the use of false testimonials. So this can be relevant to the health sector in terms of representations that perhaps a particular celebrity supports a particular kind of cure or alternative medicine, or false testimonials purporting to be testimonials from other patients or consumers who have used a particular alternative medication or treatment. Another example is representations that a particular treatment has particular benefits, for example, curing cancer when it doesn't, or even the need for any goods or services. So representations around the fact that if you have breast cancer, you need this particular alternative treatment. With section 29, the benefits of 29, even though it's quite specific, are that it enables the ACCC, if it pursues it, to obtain financial penalties against the offenders. And this we see as a particular deterrent factor, particularly in cases where there's scope for people to have made quite a bit of money from promoting these alternative therapies. The other relevant provisions under the ACL are the unconscionable conduct provisions. These are particularly relevant in circumstances where consumers have expended significant amounts of money for alternative treatment and perhaps have come under pressure to make additional payments to keep the treatment going. And an example of that, which I'll talk about later, is the New Era matter. So the ACCC can't pursue all the complaints that it receives about the conduct of traders and businesses, and we rarely become involved in disputes that are just between an individual consumer or a small business dispute. However, whilst we carefully consider all the complaints we receive, and we use our enforcement and compliance policy to assess which of those complaints warrant our investigation. And the types of factors that we take into account there include the potential for harm to the competitive process or a result in widespread consumer detriment. A copy of our enforcement and compliance policy is available on our website. It's reviewed annually, and it sets out our enforcement powers, functions, priorities, strategies, and compliance regime. So as I noted earlier, one of our priorities for this year is the medical and health sector. In addition to having specific priorities, there's certain types of conduct which we will always consider worth pursuing, and that's where there are aggravating factors, including the potential to undermine government policies or initiatives, where it's targeting disadvantaged or vulnerable consumers, and if the conduct is particularly widespread. Other factors that can also influence whether we will pursue a particular matter is whether there is another regulator that is already dealing with or has the appropriate tools to deal with a particular response. And we regularly liaise with AHPRA and the TGA and also our state consumer affair counterparts to consider which regulator might be best placed to pursue particular allegations. So some examples of where we have taken action in relation to health and medical claims. The examples I'm going to talk about today all relate to situations where we've taken action in the federal court and received and obtained court outcomes. However, we do also pursue a number of matters administratively or with less resource-intensive enforcement options, including court-enforceable undertakings and infringement notices, which have a financial penalty of $10,800. And these remedies are often suitable for the less egregious conduct. But the particular examples I'm going to talk to today are ones that we obviously considered were particularly egregious and warranted court action. So the first one that I've got there on the slide to talk about is the Menopause Institute. And this was a broad campaign. It ran across newspapers, television and radio, so it had the potential to reach a wide number of consumers. It made representations around a natural hormone replacement therapy as an alternative to the normal hormone replacement therapy. It made representations that it reduced the risk of cancer, among other diseases as well, and that it was proving to be safer or at least just as effective as conventional HRT. So some of the factors that influenced the ACCC in taking that action related to just how widespread the marketing of it was, and the fact that it was therefore likely to reach a large number of consumers, and it also had the potential to divert consumers from legitimate healthcare treatments. The next matter on that slide there is the one I referred to earlier, which is the New Era matter, which concerns the RANA system. And this was specifically a system that was marketed as an alternative approach to cancer care, which offers hope to cancer sufferers. This matter raised not only issues in terms of misrepresentations, but also unconscionable conduct in that consumers were pressured into paying large amounts of money, up to $35,000, for treatment under the RANA system, which the court declared was unconscionable conduct. It also offered a range of therapies, some of which we've already talked about tonight, that had the risk of being particularly detrimental to users of the therapies. Another couple of cases that we've looked at more recently are the allergy pathway case, and this one, I guess, highlighted an instance of where there was a real risk to consumers that by following the treatment they could actually cause themselves harm. The treatment offered an alternative to and suggested that an allergy could actually be cured or eliminated through the treatment. And in fact, there was a real risk to consumers with food allergies that if they underwent the treatment, they could actually suffer further complications as a result of their allergy. And then the next case I have up there talks about some breast imaging services. These were two particular services that offered alternative screening processes to the mammogram and provided false representations that there was actually an adequate scientific basis for assessing whether a consumer was at risk of breast cancer, and also a basis for assuring a consumer that they did not have breast cancer. Finally, and more recently, in 2012, the ACCC took action against Homeo Plus Proprietary Limited. This is an interesting one because the ACCC had previously raised its concerns with Homeopathy Plus about representations of the effectiveness of the whooping cough vaccine. The company removed the representations from its website but subsequently reinstated them. And on that basis, So that's an example, I guess, of where the ACCC initially took the approach of trying an administrative resolution. It raised its concerns. It believed that the trader had taken them into account and changed its conduct. However, when it reinstated the claims again 12 months later, the ACCC instituted proceedings in the federal court in relation to that. And the types of orders that the ACCC typically gets when it takes these sorts of actions are orders for corrective advertisements or corrective notifications to consumers where there's been significant outlays of money. It can seek compensation orders or refunds for the consumers. And under Section 29, as I said before, it can also seek financial penalties, pecuniary penalties. The penalty range is quite large and is up to 1.1 million, depending on the severity of the conduct. And finally, how to make a complaint. You can make complaints to the ACCC through our info centre. You can do that by telephone, or there's an online form on our website. It can be helpful to ring our info centre. They can give you some guidance initially on whether it's a matter for the ACCC or whether there's another regulator who might be better able to assist you. All of our complaints are logged into our recording database and reviewed in any event to make sure that there's nothing that has been referred off that in fact is something the ACCC should be considering. From the ACCC's perspective on whether you need your patient's consent to make a complaint to us, it really depends on the details that you're needing to provide to us. Where you're making complaints, for example, about advertisements or representations in publications or on the television and so on, then there's no need specifically to refer to your patient. You can provide us with copies of the various representations and we can pursue our investigation based solely on that. However, if the representations that you're making a complaint about are oral representations that have been made by someone to your patient, then ultimately if the ACCC were to pursue it, it would need evidence of those conversations. That means it would ultimately need someone, whether it was the patient or a family or friend or yourself who was present at the time of the representation, to be prepared to give evidence to that, to those conversations. And so in those situations, we'd recommend that you discuss it with your patient before contacting us. As I noted earlier, the ACCC carefully considers all complaints but can't pursue every matter, and so we use our E&C policy to assess matters. When we decide not to pursue one, we may nevertheless draw the possible contravention to a party's attention and provide them with information to rectify or ensure that they're complying with the ACL. Or we may place them on notice, and should we receive further complaints, reassess whether it's a matter that we should be taking on.
Okay, thank you, Heidi. And at this point, we'll hand over now to Dr. Grant Davies, the Health Services Commissioner in Victoria.
Thanks very much. I'm delighted to be here. I was saying to the panel that this feels like Back to the Future for me. I used to give some sessions on ethics in the Queensland Cancer Fund, so I'm really pleased to be here. So the Office of the Health Services Commissioner receives complaints from consumers of healthcare about health services in Victoria. We're one of a number of state and territory what are called health complaints entities across the country, and we all have slightly different legislations. So, for example, in New South Wales and now Queensland, they have what's called a co-regulatory approach. So they have a dual role with AHPRA and their tribunals, whereas we have a very separate role in Victoria. We manage complaints that don't reach the thresholds around professional misconduct or unprofessional conduct that would need to be referred to AHPRA. We consult with AHPRA on every registered practitioner complaint that we receive, so regardless of whether we receive it or whether AHPRA receives something that might fall within our jurisdiction, each organisation consults with the other about who's best placed to handle the matter. We're an independent, impartial and free service. And we take that very seriously. We sometimes get angry consumers suggesting that we're not advocating on their behalf, but that's not what we do. We need to be independent and be seen to be independent. Those two pieces of legislation, the Health Services Conciliation and Review Act and the Health Records Act, are the two pieces of legislation that we administer. The Health Services Conciliation and Review Act has been under review for the last 2 to 3 years. There was an expert panel report that was published a couple of years ago, which outlined some improvements through our legislation. Part of that process was that we commissioned was a study of complainant satisfaction with our service. It was the first of its type in Australia, and what it found was that we weren't really meeting people's needs very well. So we, when we're managing complaints, talk about complaints as being important quality improvement processes. It's easy for us to talk the talk, and we needed to walk the walk. So we've undertaken a large amount of review and process redesign in our office, including organisational. And fundamentally what it's done has meant that we have streamlined our service so that we have a much simpler process for people to work with. So what can be complained about? Well, unsatisfactory healthcare, communication issues, a lack of respect or dignity, failure to provide a health service. Each of our acts have what are called guiding principles, which are really touchstones for the way health services should behave in Victoria, and they cover things like informed choice, quality improvement, participation. Interestingly, the Health Services Conciliation and Review Act does not have a protection of the public guiding principle, and I think in a review of our Act we really need to see that included. Negligent or unprofessional behaviour is something that can be complained about, and because we have a health privacy and a health records jurisdiction, breaches of health privacy can be complained to us about. The sorts of outcomes that can be achieved in our process, unsurprisingly, are an explanation. Interestingly, we did some research in the office which did an analysis of 10 years' worth of conciliation that we've done in the office, and we found that factoring in all of the factors, about 85% of our complaints are resolved on the basis of an explanation. That's a huge amount of achievement, and in fact, the literature often talks about apology as being a really powerful tool in complaints resolution, but we would argue that explanation is actually as equally, if not more important than apology. If you add apology to that figure, it reaches about 93 to 95%. We can sometimes achieve a change in policy or procedure, get a service for someone, improve a diagnosis or treatment option for them, and less frequently, compensation. We find that it's on the lower side of the spectrum. Again, we did some analysis on 5 years' worth of conciliation data and found that the vast majority of compensation was under $5,000. It was a refund of fees or something that was under the Medicare threshold. Less frequently, I think about 8 to 14 reached any sort of level that would require a significant compensation payout. So the sorts of issues that we can deal with, treatments, no surprises there in terms of that being the largest issue that we deal with. This is last year's data. We haven't, our annual report is due to be tabled in Parliament tomorrow, so I can't really disclose those data here, but you will get the general gist of the types of issues that we deal with. So treatment's often the most popular. Access, in terms of, they're not providing me with a service, and communication. Interestingly, communication, whilst we say is 11% worth of our primary issues, we know that most of our complaints in some way have a miss or poor communication aspect to them. Over that 12-month period, there were 33 or around 1% of our complaints received about unregistered providers. Under the Health Records Act, access and correction, I won't spend too much time here. We're probably sort of focusing on the treatment issues. Use and disclosure, data quality and collection all form part of the Health Records Act complaint space. You'll see that the vast majority of our work occurs under the Health Services Conciliation and Review Act. Interestingly, those Health Record Act complaints are increasing over time. I think they were up 50 cases there, and they'll be up again this year. So we get around 8,500 inquiries a year, and they can come in a variety of ways: on the phone, through email, through online complaint form, through a written complaint, or in person. We tend to deal with things much more informally these days, where we pick up the phone and talk to services and say we've spoken to this individual and we think we can help. We think you can resolve this complaint by sort of addressing these issues, and by and large, the complaint resolves at that point. The 8,500 inquiries translates into around 3,500 complaints per year. We've had a 30% increase in our complaints over a 5-year period. We haven't had a 30% increase in our resourcing over a 5-year period, which is not unusual in this space. We've got 25 staff, 17 of whom are direct complaint handlers. So we're pretty lean, and in fact the Productivity Commission did a report last year that did an analysis of the costs per contact for all of the health complaints entities across the country, and we were by far the most efficient, let's put it that way. So how do we resolve complaints? Well, we assess a complaint for whether it's within jurisdiction or not, and if it is and it's suitable for informal resolution, we will try and resolve it that way. That will sometimes mean writing to someone. It's worth noting we also take prisoner complaints. We have jurisdiction over healthcare in prisons. That can be a challenge because obviously you can't call people back when they're in prison. So that has its own challenges, but we find that a vast majority of those are resolved informally as well. So if it's not able to be resolved informally, or if it's been unsuccessfully resolved informally, we will refer the matter into conciliation. Conciliation is an alternative dispute resolution process which is both privileged and confidential. So anything said or disclosed within that process can't be used in a court of law, can't be used by a registration board, can't be accessed under FOI, and I can't use it as a basis for an investigation. So it's a safe space. It has raised some issues for me around, well, what happens if someone discloses a criminal activity in that space? And it's an issue, I think. And I think public interest disclosures will form part of any review of our Act. If that's not suitable, if a complaint's not suitable for conciliation, or it's or something arises that requires the matter to be investigated, conciliation will close, or the matter will be referred directly to investigation. And this really is where some of our unregistered practitioner complaints sit. Some years ago, I think it was 2006, we undertook, the office, my predecessor undertook an investigation into a man called Noel Campbell. He was a dentist who was administering ozone for the relief of dental pain. Not sure how that works. But he relinquished his registration before the Dental Board of Victoria, as it was then, could strip him of his registration certificate. He then set up shop as a cancer quack and started administering ozone there and electromagnetic therapy, as he called it, which was just a revamped transistor of some description. We did an investigation on him, made a series of recommendations, including that Consumer Affairs Victoria investigate the matter for misleading and deceptive conduct. They did so. They made a series of findings, prohibited him from advertising. He appealed that to the Supreme Court, and the the Supreme Court judge, singular judge, found largely in his favour over a series of claims, which were then appealed by Consumer Affairs to the Appeals Court, and the Consumer Affairs won that trial. And in fact, what came out of that was, regardless of all of that attention and interest both in the media and in the legal system, he could still practice. There was no capacity for us to prohibit him from doing the kind of work that he was doing. So that's a real problem for us, and something that is likely to be addressed in the not too distant future. So health ministers have agreed to a code of conduct for what they're calling healthcare workers, but really relates to unregistered providers. Excuse me. They did that in April this year, and they've agreed to implementation of that code in each of the states and territories at some point under state-based legislation. The definition of health service is very broad, and what would go with that would be what's called a negative licensing scheme, although that's not a popular term. But you'd be able to make public statements, public warnings about individuals, and be able to apply prohibition orders to stop people from practicing. This scheme is in effect in Queensland, in New South Wales and in South Australia. Part of the agreement was also some interjurisdictional recognition of prohibition orders and any statements by any other jurisdictions in relation to individuals, so people can't close up shop in New South Wales and then set up shop somewhere else. The Code of Conduct itself covers things like healthcare workers providing services that are safe and ethical, that they conduct themselves in accordance with infection control standards, that they don't make claims to cure certain serious illnesses, etc. So it's relatively broad, but it's quite comprehensive. So the review of my Act, as I indicated, has been some time in the making. A piece of legislation was introduced into the Parliament last year and was not voted on before the Parliament was prorogued, so the bill lapsed, sadly. The current Health Minister has agreed to pick up where that left off and has done a limited consultation round, and I'm anticipating that there'll be some movement in terms of a new bill sometime next year. But part of that consultation round sought some comment on a broader definition of health service. One of the things that I find particularly difficult is that unless a provider falls within a particular category as set out in our Act, I can't deal with it. So things like cosmetic surgery, for example, are very difficult for me to deal with. There will also be an expanded capacity for people to complain. So at the moment, only consumers of health services or their representatives are able to complain to us about the care that the consumer receives. That will be broadened out to include carers, about how the carers are treated, and in fact a much broader definition of who can complain. A more flexible and responsive complaints resolution approach, but I've done significant work on that already in preparation for that. Greater public protection, the negative licensing scheme I've spoken about, but there may also be capacity for what's called a Commissioner-initiated or own motion investigation, so that I can act on information or intelligence that I receive about particular issues without requiring a complaint to be received. And indeed, there'll be an increased capacity for me to work in the quality improvement space. So, if we're not able to resolve a matter through either investigation, and it's worth noting, or conciliation, and it's worth noting that in investigation, I can only make recommendations at the moment. I can't prohibit people from practicing. I can't make public statements without going through a number of procedural steps, and I can only do so in the Parliament. So it's a quite limited capacity for me to act on those things. The Act is something like 28 years old, so it is due for a bit of a review. If a matter relates to a registered practitioner, and we know that sometimes registered practitioners no longer work in that area of expertise, but then work in alternative areas, we could refer that person to AHPRA, both initially and out of conciliation. People can take legal action, both civil and criminal, under the Health Records Act, and indeed in the small claims area of VCAT, people can take people to VCAT. And of course, there's a capacity to complain to Consumer Affairs Victoria. And if you need any other information in relation to the work that we do, there are our contact details. Thanks, Sonia.
All right, thanks, Grant. So at this stage, that brings us to the end of the webinar content, and we will now move into our panel discussion with each of our presenters tonight, Tony, Deborah, Heidi and Grant. And our panellists will firstly respond to a case study. And we'll also look at some of the questions that have been posed by participants at the time of registration. And there will be an opportunity to ask further questions in the Q&A session for those who stay online. So we're going to, as I mentioned, open up the panel discussion by considering this case study. And firstly, we will look at the case study, which is a female patient with a brain tumour who was taking a morphine mixture to her alternative therapy provider, who took it out of the room and detoxified it before returning with it. And that the patient found that the service on a website promoting the harms of conventional cancer treatments, including drugs such as morphine, and the potential for specialty diets to cure or slow cancer. The patient had paid $2,000 for detoxification of morphine, and she saw nothing unusual or suspicious about this and felt it was useful to get rid of the toxins. So at this point, Tony, would you like to make some comments and just talk to us about how you might discuss this therapy with this woman if she was one of your patients?
Yeah, thank you. So I guess this brings up a number of important points that I guess we've tried to highlight as this webinar goes on. But I guess sort of the obvious thing that stands out for me here is the $2,000 that she's being asked to pay. I mean, morphine mixture is something that's a medicine that's already regulated. We know a lot about how it's made and things, and it really doesn't need anything added to it because that's where all the safety precaution things are already in place. So, and you can get morphine depending on whether you're on a subsidised script or not for a hell of a lot less than $2,000. So these sorts of things always ring alarm bells when you see such a large amount of money being asked for people to pay, and I think that then plays onto their vulnerability. So morphine clearly doesn't need to be detoxified, and you can also see there that the website is promoting harms of conventional cancer treatments, which is often what these do. Like, you shouldn't be going through the conventional things. We have this alternative for you. So I think it can be very difficult. I think you've just got to have an explanation with the women and often with their family about why they think this is necessary, point out that morphine doesn't need to be detoxified, but try and find out the reason behind it, and then I guess just sort of point out some of the flaws as you see it and try and gradually work your way forward. You have to go slowly, and you have to get their confidence, because otherwise my fear always is that they tend to sort of avoid standard cancer care altogether and go to the alternative health provider, which in this situation I would argue is doing a poor job. So you don't want to lose them, but you do need to point out that it is absolutely unnecessary to pay $2,000 to detoxify morphine.
All right, thanks, Tony. And Heidi, so if at the ACCC, how would you respond if one of the women's family members, friends or medical team called the ACCC about the claims being made by this alternative therapy provider?
I think certainly this is one that we'd be interested in having a look at. And so for us, really all we would need in terms of the complaint is the details of the website and from the practitioner, even just what their concerns with it were. That would be enough for us to make an initial assessment of it. Interestingly, one of the things with the ACCC is that we can only generally take action against corporate entities rather than individuals. However, even if it was an individual, because it's over the internet, that would give us jurisdiction as well. So, and given that the internet does give people it gives a platform for a broader consumer detriment, it's something I think that we would certainly make some initial inquiries about. I think where we would end up is that we'd be seeking some information from the provider to have an understanding of just how often they've been providing this service, how much money they've been making from it, to understand the detriment as to how seriously we viewed it.
And Grant, for you, how would your office respond if one of the women's family, friends or medical team called to complain about the treatment being offered by the alternative therapy provider?
We would need the authority of the woman herself to be able to proceed with the complaint, provided she was prepared to authorise an individual to act on her behalf during the complaint. We'd be very happy to take them.
And would it make a difference if the woman had said she was unhappy with the service that had been provided?
Which service?
The
alternative? Yeah, well, it may, although, again, you wouldn't expect someone who was happy with the service to agree to have it complained about. So, yeah, so we'd be very keen to have a look at that and hold registered practitioners like that to the guiding principles that are.
All right, so thank you. We'll move on to have a look at some of the questions that had been posed at the time of registration by some of our participants. And for the first question, I'll ask all of our panellists to offer their perspectives. And the question is to discuss the ethics of reporting concerns about alternative therapies without patient consent. So, Deborah, would you be happy to start with this one?
Sure, thanks, Sonia. I guess I'll speak from a legal ethics perspective in response to this. Obviously, confidentiality is a vital component of the clinician-patient relationship because it encourages and reassures patients that they can be open with their clinicians, which is vital to ensuring that they feel comfortable and confident to tell their clinicians everything they need to know to treat them effectively. So it's preferable, obviously, that health practitioners have their patients' consent to report a concern about an alternative therapy provider. But I'm sure everyone's also aware that the duty of confidentiality isn't an absolute duty, and there are exceptions, such as when public health or safety is threatened. So, for example, if there's a risk of serious harm to the patient or to another person, or there are overwhelming societal interests. And as I said before, there are mandatory reporting duties too, which may involve breaching confidentiality. Whether it's justified will probably depend on the level of risk and harm. So the risk of harm would need to be sufficiently grave to outweigh the very strong public interest in confidentiality. And when breaching confidentiality is justified, it can still only be breached to an authority that has a proper interest in receiving the information and has the ability to mitigate the risk. So you can't just breach confidentiality to anyone, and the amount of information that's divulged must be restricted to that necessary to reduce the risk. And I think it's an interesting question of whether the Health Services Commissioner or AHPRA or the ACCC would be considered to be in that position of being able to mitigate the risk. I'd be interested to hear your views on that. But if you don't have patient consent and you don't think there's sufficient public interest to justify breaching confidentiality, then clinicians would need to consider whether they can report their concerns without disclosing any confidential patient information. So as Heidi mentioned, if it's publicly available information, then that's going to be a lot easier to report.
The Health Records Act talks about a serious or imminent risk for disclosure. And I think the important aspects of that are both serious and imminent. So you need to be able to demonstrate that both of those things to be able to breach confidentiality.
Serious or imminent?
Serious
and. So that would be difficult usually, I would imagine.
It's a pretty high bar.
We're talking about.
It's a pretty high bar. And you know, I think public interest, trying to weigh up the public interest issues are quite difficult on the run. So, we've had people on our intake line suggest that they would go and harm particular practitioners or bomb hospitals, and that, in our view, enables us to call the police, for example. It's less clear when you're talking about something that has a tenuous link around whether it's actually doing harm or not.
And Heidi, from ACCC's perspective?
I think from the ACCC's perspective, the majority of the types of complaints that we could deal with, you could probably provide information to us that wouldn't breach your patient confidentiality. So you could give us sufficient information in general terms about a trader, about claims that they were making, without needing to give the specifics of any individual complaint. The times where that might differ is where you think that there's been unconscionable conduct, because that will be more specific to an individual patient. If you've got concerns about unconscionable conduct, you can still make a complaint more generally about a particular trader and your concerns that they are engaging in that sort of conduct. And I guess then, depending on the level of detail without disclosing, so you could disclose generally the circumstances without naming the particular patient, that may give the ACCC enough to make its own inquiries and to uncover conduct of its own through its own investigation.
And Tony, from the clinician's perspective?
Yeah, I find this quite difficult. I mean, I have to say, I've never had a case where somebody's come to me after an alternative therapy hasn't worked, and then you have a chat to them and you try and ascertain why they've done it, for them to sort of turn around and say, well, I'm going to therefore report person X or health practitioner Y. And I know the Cancer Council for a number of years has been interested in people coming through them to sort of help in this regard, and you just don't see it. They're quite fixated in their views about what they want, and that example I gave right at the start about running away from the needle. I've had conversations with people saying, what in your mind would it take for you to realise that this treatment wasn't working? And they just say, when I'm told it's not working. And I've shown people scans where a mass in their lungs is getting bigger, and you sort of say to them, well, isn't that evidence that this treatment's not working? And they just say, no, well, if I'm told it's working, I'll continue the treatment. So it can be very hard. I mean, obviously, if it's somebody connected with AHPRA, I now have a duty of care to report those, but then most of the time this falls outside that jurisdiction. So I guess in my own hospital we would have a mechanism where I can discuss it with my peers, we can escalate to the Chief Medical Officer, sometimes we have discussions with the Health Commissioner, but it is actually very difficult, and I guess you try very hard to get the patient to be the one, but I've never come across a patient that's prepared to do that. I think also they've paid a lot of money and they've invested a lot of emotion into it, and I think it's very hard. They need to save face. So you normally just say, well, why don't you try this, and kind of just lead them, and then at least you think they're getting effective care. But I always have the concern that there are people out there doing bad things, basically, but I find it's actually very hard as an oncologist to know how to refer them to what's different, which is obviously the whole point of tonight, the discussion. But it's not easy.
Oh, I was just going to say, it is very difficult when people who have capacity and are competent to make decisions that you or I might believe are poor ones, and respect their autonomy.
That's right. At the end of the day, you have to respect their autonomy as well. They have the right to choose alternative treatment.
All right, we might move on to our next question at the stage, which is to discuss the potential liability of a patient's medical team or hospital in respect of the patient's use of alternative therapies. And Deborah, if you'd like to lead this one again.
Thanks, Sonia. I think this is a pretty difficult question to provide a definitive answer to, so I'm just going to give people some things to consider, I guess. And it will need to be assessed on a case-by-case basis. It's well established in the law of negligence that clinicians have a duty to take reasonable care with respect to examination, diagnosis, treatment, and the information that they give to patients. So it's really important from the patient health perspective primarily, but also if you're considering potential liability, that clinicians know the other medicines and therapies that their patients are taking or using. Otherwise, there maybe risks of adverse interactions or reactions between the treatment that you're providing and any other therapies that they may be taking. So as Tony mentioned at the beginning, it should be standard practice to ask about all of the treatments or providers that a person's accessing in respect of their health issue. And in some cases, it could be useful to speak with the provider of the alternative therapy if the patient consents and if the provider is willing to participate in that discussion. If the patient isn't very forthcoming about the medicines or the therapies that they're taking, then it might be worth trying to engage their family in those discussions if the patient's willing to allow that. There's obviously a limit in terms of how far you can press the patient about what they're taking, but you do probably have to press to a reasonable extent if you're concerned about the interactions of what you're providing versus what they might already be taking. So it might be necessary to say something like, it's not safe for me to treat you if I don't know what else you're taking, which might assist you to discharge your responsibility in terms of informed consent and taking reasonable care with your treatment. But that has to be balanced against the possibility the patient will prefer the alternative treatment to the one you're offering if they feel like you're forcing them to make that choice. So I think, as I said, this is a really difficult question. So I think it's really important to keep an open dialogue with the patient so they do fully understand the risks of their choice of their alternative therapies and of delaying or refusing conventional treatment if that's what's happening, and making it really clear to them that you need to know what's going on in order to treat them safely. I think perhaps Tony might speak to this as well, but checking your own health service policies about allowing administration of other medicines or therapies within your service. I would imagine that many of them are fairly conservative on that front. It'd be useful to discuss things like this with your colleagues, obviously, and people higher up. And I guess it could be particularly concerning if there's family or caregiver disagreement over the treatments being provided, then that might increase the risk of going down the track.
All right, thanks, Deb. And Tony, from the again, clinician's perspective, but also perhaps the broader hospital or health service issues.
I think this is a situation where the hospital has tightened up over the last few years. We don't, well, certainly in the institutions that I work in, generally we don't allow you to self-medicate any medication. So it's not just alternative therapies. We need to know what you're on. And I think patients and their relatives don't always understand. The hospital has a response. We're looking after you. You're under our care, not just the medical team. So we do need to know what is going on so we can try and prevent any adverse consequences or outcomes. So as I said, so we don't allow them to self-medicate prescribed medication either. When people go into a hospital, by and large, other medications are dispensed. And if people come in with blister packs or anything, we don't know what's in it. We have to actually administer known medications. So that's just the way the hospital works. I think that's appropriate. Where it becomes difficult is, and often in the situation where there might be an elderly person who's non-English speaking, and their well-meaning relatives are the ones that want them to have an alternative therapy. They often don't want their loved one, usually an elderly person, to be told they've even got cancer, yet they want them to have these alternative therapies. And I think if I have to be the advocate for the patient in that regard, and that they need to know what's going on so they can have an informed discussion. So we would, involve the use of hospital interpreters or even cultural liaison people, sometimes even our psycho-oncology service, to try and make sure that effective communication is optimal as possible, and also that they're informed. The patient doesn't have to know what's wrong with them, but they have to at least be asked the question, do you want to know what's wrong with you? Do you want to know the results of your test? They say no, that's fine, but they at least have to be given that opportunity. And I think it's all part and parcel of the same thing. But we do try very hard to not get relatives and patients offside, because you're right, they may then leave the system altogether. But alternatively, we can't have them being in hospital under our care using therapies that we don't know what they're having. So we don't allow it, but we do try and work together, so it's not sort of an us versus them approach. But it can be tricky.
All right, we'll quickly run through our last question, which is quite a specific one, and we'll go to Heidi and Grant for this, which is there anything that you could do, or as a health practitioner, that you could do when a stall at the local market is selling black salve with a poster stating cure your cancer? So firstly, Heidi from ACCC.
So I guess the initial thing is firstly that the TGA has actually issued warnings around black salve. So in terms of if that's what they're selling, then the first port of call I think would be the TGA, and that's who you should notify about that. If it's something else that they're selling, but they're stating that it'll cure cancer, then in the context of a local market, it's probably something that's more appropriate for Consumer Affairs Victoria or the local state fair trading agency rather than the ACCC. However, if it's something that's being sold online, as I indicated earlier, or has a broader reach through a number of stores or outlets, then you may want to consider referring it to the ACCC.
Grant?
And, you know, without a complaint in relation to it from a consumer of the black soul, there would be nothing that we could do in relation to that.
Okay, all right. Well, thank you. In view of time, we are going to just close off our webinar at this point in time in our panel discussion. If you are interested, you can listen to our previous webinars conducted for patients and carers, and those links will be available to you at a later date. I would like to thank our panellists, Deborah, Tony, Heidi and Grant, and also the Cancer Council staff from the McCabe Centre Clinical Network and Cancer Information Support Services teams. Just a reminder, we will be closing off the audio, and at this point we'll be enabling the question and answer function. This will be available to answer your questions until 7:15. I would also like to ask any or all of the presenters, please click on the icon in the top of the right-hand corner of your screen, and questions can be answered publicly or privately. And if your questions are sensitive in nature, we will answer them privately. And if it is a general question that could be of benefit for all, we will answer it publicly. And please indicate if your question is to be answered privately. And please note that also all of the questions will be viewed by all of our panellists. We do hope that you have enjoyed the webinar, and thank you for your participation. And we do ask that once you leave the webinar, you take the time to complete the exit survey, which will take about 5 minutes to complete. And at this stage, we will close off the audio and move to the Q&A. Thank you.